State of Wisconsin, Plaintiff versus Stephen Avery, Defendant. Motion hearing, case number 05-CF-381. Date, April 13th, 2006. Before Honorable Patrick L. Willis, Circuit Court Judge. Appearances: Kenneth R. Kratz and Thomas J. Fallon, Special Prosecutors, on behalf of the State of Wisconsin. Dean A. Strang and Jerome F. Buting, Attorneys at Law, on behalf of the Defendant. Stephen A. Avery, Defendant, appeared in person. Transcript of Proceedings. Reported by Diane Teshadek, RPR, Official Court Reporter. The Court. At this time, the Court calls State of Wisconsin versus Stephen Avery, case number 05-CF-381. This matter is scheduled this morning for a court decision on a motion that's been filed by the defense. Will the parties state their appearances for the record, please? Attorney Kratz. Your Honor, the State of Wisconsin appears by Calumet County District Attorney Ken Kratz, having been appointed as special prosecutor in this case. The state also appears this morning by Tom Fallon. Tom is with the Department of Justice, also having been assigned special prosecutor in this matter. Attorney Strang. Good morning. Stephen Avery, second to my right. He's in custody. Dean Strang, appearing on his behalf, and Jerome Buting, also as counsel for Mr. Avery. The Court. All right. I will indicate for the record that the motion that's the subject of the hearing today is a motion that was filed by the defense, renewing a previous motion that the new charges in the amended complaint should be dismissed, or in the alternative, if the court permits the filing of the charges, that the defendant be entitled to a preliminary examination on the new charges. I will also indicate for the record that I met with counsel in chambers briefly before we began this morning, and as I understand it, the defense would like the opportunity to supplement its written argument with the court, which the court has already received and reviewed, and the prosecution would like a chance to respond. Is that correct, Mr. Strang? Attorney Strang, it is. The Court. All right, I will hear you at this time. Attorney Strang. I will not belabor the written arguments nor repeat arguments made at the initial oral motion to dismiss the complaint, leaving in summary my argument on the motion to dismiss the complaint, that when the United States Supreme Court, probably close to half a dozen times since 1968, has explained that statements against declarant's interest that then go on to inculpate another person are unreliable, that those sorts of unreliable statements fail Wisconsin's reliability requirement for the factual assertions in a criminal complaint. The court already has ruled adversely to me on that. I have renewed the motion in writing, and I will leave an argument there on that point. As to the question of a preliminary hearing, if the amended complaint is allowed to stand, I confess that I had become occupied, if not preoccupied, with Burke and Bailey and the profusion of case law, criminally, from the Wisconsin Supreme Court that make very thick, I think, intellectually interesting, very complicated, the law in an area in which the underlying statutes, at least to my eye, look fairly straightforward, but now have been construed, or rather with such gloss, that there's nothing at all straightforward about the area of the law. And I became very interested in that case law and what it all means, where it sorts out and applies here, as the focus of my briefs. I think also the focus of the state's written submissions. And so I have written arguments that suggest to the court why it should grant a preliminary hearing here, and I think overlooked a statutory command that the court shall order a preliminary hearing in the unusual procedural posture in which we find ourselves here today. We stepped back early in mid-March. The state's request was for leave to file an amended complaint and leave to file an amended information. We took issue with the first of those requests to file an amended complaint. That was the briefing. Our opposition to an amended complaint, or to the request that he be granted to file an amended complaint, was the thrust of the briefing that brought us here the last time before Your Honor. The court overruled my position and did grant the state's request to leave to file an amended complaint. That occasioned my oral motion to dismiss the complaint for want of probable cause, and we covered that ground already. But we are not here today on a request for leave to file an amended information only. We're here with an amended complaint now having been filed on leave of the court, no initial appearance having been made on that amended criminal complaint. And I think, therefore, we're within the field covered by Wisconsin Statute Section 970.02, and for our purposes here, narrowly 970.02, 5 in parentheses, which governs the initial appearance and what's to happen and at and after the initial appearance. And the question is, or the statutory command is, that if the defendant does not waive the preliminary examination, the judge shall forthwith set the action for a preliminary examination under Section 970.03. That's the preliminary examination we seek. We're certainly not waiving it. The question becomes somewhat circular because if we don't have a right to preliminary examination for some reason in the first place, then there's nothing that we would be asked to waive or properly could resist waiving. I don't have any case law construing 970.025 in this setting, or anything that I can offer today from which the court might draw guidance other than statutory language. But the procedural posture, I think, is indisputable. We are here with the court having granted leave to file an amended complaint, which is what the state had requested. We are here on an amended complaint. There has not been an initial appearance on that amended complaint. The amended complaint adds 3 new charges, not before seen in the course of this case to date. We, of course, have disputed whether those are transactionally related to and derived from the evidence at the earlier preliminary hearing. We think they aren't. The state thinks they are. But the fact is, this is a new complaint, and it is a complaint on which the case, as to the 3 new charges, presently is founded. We don't waive the preliminary hearing. We think we have a right to it. And we think the statutory command is clear, that the court shall schedule a preliminary hearing forthwith on the 3 new counts. The court. All right, Mr. Kratz or Mr. Fallon? Attorney Kratz. Judge, Mr. Fallon wrote the brief on this issue, and with leave of the court, I would like him to argue this today. The court. Very well. Mr. Fallon? Attorney Fallon. Yes, thank you, Judge. Good morning. I think I feel compelled to address counsel's concern regarding the posture of the case and whether or not an additional preliminary examination is needed at this time. We're finally convinced that no such examination is needed for both a practical reason and a legal reason. The legal reason being, quite frankly, this is not entitled to one. And I say that because, interestingly enough, the defendant has received a benefit to the fact that the state sought and did, in fact, file an amended complaint. which was jurisdictionally unnecessary. The defendant has been provided far more information relative to the additional charges than the law in Wisconsin normally permits. So he has received a benefit already, one to which he was not entitled, one in which, as a result of which, no preliminary examination is required under the law. Once the original charges are filed, once a court finds probable cause at a preliminary examination and binds the matter over for trial, the information becomes the governing procedural document, the document upon which this court may exercise its authority and power to determine the course of action for the parties. In this particular case, additional information came to pass, which ethically permits the prosecutor, and also based on the transaction-related law that each side has briefed rather thoroughly, to add additional charges. Assume, for the sake of argument, this court had granted the defense motion to dismiss the complaint. Would the state be precluded from being in the exact posture we're in right now? Absolutely not. As the court is aware, and the parties are aware, the cases of State v. Bailey, State v. Burke, State v. Richer, State v. Williams, State v. Akers, State v. Bury, all occurred and were litigated in the context of post-probable cause, based upon the original complaint and a subsequent preliminary examination, and no additional or amended complaints after bindover. So, in effect, the defendant has received a benefit based on a local custom and practice to provide additional information should, in the average felony case, the result a change of plea. The parties would have a factual basis upon which to make a determination to accept a plea, to refer the matter for further pre-sentence investigations, what have you. A current local custom and practice, but one which is not jurisdictionally required, and nor should it be. So, even if the court had granted the motion to say, no, I'm not going to let the state file an amended complaint with these additional counts, the state would not be precluded from seeking leave to amend the information for the reasons stated in the state's brief, that the additional charges are transactionally related, or to borrow the phrase, not wholly unrelated to the transaction which was the subject of the preliminary examination, that is, the murder and mutilation of Teresa Halbach. I would also note, parenthetically, that even if we were to get it wrong, so to speak, any error relative to preliminary examination is cured by a fair, impartial jury trial. And that's States v. Webb. And I see that possibility of no error because he is not entitled to a preliminary examination. And thus, looking at the law as cited in Bailey, Burke, Richer, Williams, Atkins, Berry, the case that follows Bailey, I'm not going to reiterate the points of my brief. I think they are very clear. The state is entitled to add the additional charges because they are transactionally related, and there's no legal requirement. There's no jurisdictional imperative to have a preliminary examination ordered on those complaints because those complaints were not required by law. They were not jurisdictionally mandated. They were not necessary. They were provided as a courtesy. And I would note that 99% of the defendants in Wisconsin law find themselves wondering, well, geez, how did that prosecutor add these additional counts? None of them had the benefit of an additional information being provided in the complaints because they are not necessary. They are not required. They do not provide the jurisdictional predicate that the defense seems to suggest that they do. So, he has received the benefit. He has received notice. He has received the information. He is, in effect, better off at this early stage in the proceedings than all the other defendants who may find themselves in this posture. So that's the equitable argument. The legal argument is there's no jurisdictional basis. They are not required and they are unnecessary. So we ask the court to decide this strictly in the context of whether or not a prosecutor may seek leave and amend the information, based on the theory that the additional counts are either 1. Directly flow from evidence adduced at preliminary examination, or, as we theoretically and actually posit in our brief, the additional charges are transactionally related to the information, to the subject matter which was testified to at preliminary examination. We thank the court. The court. Thank you, Mr. Strang. Attorney Strang. I'm very pleased to hear my colleague, a very skilled lawyer, concede here that the complaint was unnecessary. The amended complaint was unnecessary. I don't know that I fully can accept his gracious concession to the extent that he qualifies it by saying jurisdictionally unnecessary, but it is gratifying to hear the concession that this amended complaint was unnecessary. Only lawyers, though, I think only lawyers could imagine that that unnecessary complaint conferred a benefit on Stephen Avery. The benefit is then that he has been pilloried in the press on the basis of unreliable, inadmissible, hearsay accusations in the complaint. Repeatedly pilloried in the press. The benefit has been that this court explicitly cited that information in the complaint as part of the reason for raising his bail from $500,000 to $750,000 cash. The benefit is that we are here today fighting simply to have the state stand beside and submit to the minimal testing of a preliminary hearing. The information that it has spread before the public in this amended complaint and by comments to the news media that track some of the allegations of the criminal complaint. And the state resists minimal testing that occurs at a preliminary hearing in this state where it is required only to establish probable cause. So I don't share the sense that any benefit has been conferred on Mr. Avery by this amended complaint. I do have the sense that it introduces altogether something new in this case, and I think everybody watching or listening or sitting behind me today understands that there are altogether new things that the state has been alleging since early March against Mr. Avery, and those ought to be tested by preliminary hearing. The court. All right. By way of background, the court notes first that the initial charges in the initial complaint in this case charge the defendant with first-degree intentional homicide, mutilation of a corpse, and a felon in possession of a firearm. The state sought permission, and the court granted permission, for the state to file an amended complaint, adding the charges of first-degree sexual assault, kidnapping, and false imprisonment. The defendant's motion before the court today raises two separate issues. First, the defense renews its argument that the amended complaint should be dismissed on its face, or in the alternative, the defense also argues that if the court permits the filing of an amended complaint, the defendant is entitled to a preliminary examination on the new charges. The court will first briefly readdress the argument regarding the sufficiency of the complaint. The court has already ruled that the state is permitted to add the new charges in the amended complaint, and I don't believe there's a reason for the court to reconsider that ruling at this time. There is no claim of prejudice on the part of the defense, based on the lack of time to answer the new charges. The defense alleges that there is no reliable information in the amended complaint to support the new charges. However, the statements of the alleged co-defendant can, in this court's opinion, be used to support the charges in the amended complaint under the law in the case of Ruff v. State, which I cited at the last hearing, and the court still believes that case to be the law in the state. With respect to the reliability of statements of the alleged co-defendant that form the basis of the new allegations, the court cannot presume that that witness won't be available to testify. The development of the law in the area of confrontation certainly suggests that if he doesn't testify, the state will have a difficult time supporting the allegations based on the statements attributable to the co-defendant. But the court is not aware of any law that wouldn't find that the co-defendant's statements would not be relevant if he did testify, and I believe they still can form the basis of the charges in the amended complaint. Therefore, the court does not find a basis for denying the state's request to file an amended complaint. The next logical issue to take up here today is the new argument raised by the defense today, and that is whether or not the defense is entitled to a preliminary examination upon the filing of new charges in the anticipated new information. Is the defendant entitled to a preliminary examination under Section 970.02 based on the filing of an amended complaint? The parties did not brief that issue in written form, but both parties have informed the court today that they are not aware of any relevant case law. So we're left with the language of Section 970.02 itself. Significant in the court's mind is the title of that statute. It is the duty of the judge at the initial appearance. I don't believe that the filing of an amended complaint triggers a new initial appearance in this case. It can result in the defendant responding to the charges, but I don't believe that a second initial appearance is contemplated within the meaning of the statute. 970.025 says, if the defendant does not waive preliminary examination, the judge shall forthwith set the action for a preliminary examination. Understand 970.03. Implicit in the statute is that there's a right of the preliminary examination to wait, and I think that merely postpones the question to the one that the parties have addressed at length in their written briefs, and that is the defendant entitled to a preliminary examination upon the filing of additional charges after the bind-over. I believe both parties today that the case law as it is developed does not appear to require, nor does the statutes require, the case to file an amended complaint as a condition precedent to adding charges in the information. The fact that the state has elected to do so and provide everyone with the alleged factual basis for the additional charges, I'm not sure how, absent some specific wording in the statutes requiring it, that fact alone would add anything to the argument that the defendant should be entitled to a preliminary examination. It does provide the defendant with notice of the factual basis for the state's charges, and I think that that's a benefit to the defense in the sense that it alerts the defense as to what the basis for the new charges are going to be. So I don't find anything in Section 970.02 that would independently trigger a right to an additional preliminary examination in this case. The court will move on then to what both of the parties have focused on in the written briefs as the preliminary argument, and that is when the state seeks to add charges in an information that were not the subject of the complaint at the time of the original preliminary examination, is the defendant entitled to a second preliminary examination on the new charges? I will first note that the factual basis for the defendant defendant's claim of entitlement to an additional preliminary examination is largely undisputed. The state did not produce any evidence to support the charges it seeks to add at the time of the original preliminary examination. In fact, the state does not claim it was in possession of any such evidence to support those charges at the time of the original prelim. There is no specific evidence in the record from the original preliminary examination that would support the additional charges. As noted by the parties in their briefs, the question of whether the state can add charges not included in the original complaint after a defendant has been bound over for trial following a preliminary examination has been the subject of extensive litigation over the years. The governing statutes themselves are not particularly clear on their face as far as providing an answer to this question, and the Supreme Court decisions dealing with the issue have not always been unanimously decided. The starting point is Section 971.01, which provides that the district attorney shall examine all the facts and circumstances connected with any preliminary examination touching the commission of any crime. If the defendant has been bound over for trial and subject to Section 970.03(10), shall file an information according to the evidence on such examination, subscribing his or her name thereto. The statute is somewhat ambiguous on its face and susceptible to different interpretation. One interpretation certainly might be that the district attorney is limited to pursuing only those charges supported by evidence produced at the preliminary examination. However, the Supreme Court has held many times that that is not the law in this state, and the defense in this case does not argue otherwise. The question then becomes, what is the test for determining whether the state can add additional charges? The test was stated in the case of State v. Richer, reported at 174 Wisconsin 2D 231 by the Supreme Court as follows. From our discussion in Lycum to our recent decision in Burke, we have seen a broadening of prosecutorial discretion from a rule limiting charges to those supported strictly within the confines of the evidence adduced at the preliminary, to a rule granting prosecutors the discretion to charge in the information any felony that is, quote, not wholly unrelated, end quote, to the initially charged crime. The common denominator in all these decisions was that the charges must be related to one another, either from an evidentiary viewpoint or a transactional one. We conclude that a felony not charged in the preliminary examination can be made a count in a subsequently filed information if there is evidence, direct or inferential, in respect to that felony adduced at the preliminary, or if a subsequently charged felony is demonstrated by the state to be transactionally related, that is, not wholly unrelated, to one or more of the felonies for which the defendant has been bound over for trial. This test has been adhered to in all the cases cited by each of the parties in their briefs. The parties differ concerning how they believe the standards to be applied to this case. The defense argues that the not wholly unrelated test applies to evidence introduced at the preliminary hearing itself, as opposed to the transaction, which was the subject matter of the preliminary examination.